Kratos Logistics and Ascendant Claims Services. Mr. Weiner.
Yes, thank you, Your Honors. Good morning, Your Honors. May it please the court. I'm Mike Weiner here from Tampa, Florida, on behalf of the claimant appellant Brian Layton. I'd like to reserve 5 minutes for rebuttal, please. Your Honor, we're here asking Your Honors to reverse the order of the judge of compensation claims for any of the three following reasons. Number one, because precedent matters, and because this court has previously decided this exact issue in the manner in which the claimant suggests that the judge should have decided it in the underlying case below. Number two, because the opinion or the order of the judge fails to honor the plain language of the statute when it comes to the term furnish, right? It's no iteration under which the carrier in this case could reasonably have been determined to have furnished medical care that they never knew of and never authorized. And number three, because of the plain language of the statute. Most particularly, there has been a substantial and material amendment to Section 440.19 that occurred in 1994 that dramatically changed the verbiage of the statute, and that the operative phraseology now considers that the statute of limitations shall be triggered 1 year from the date of payment. It is no longer 1 year from the date of furnishing of medical care, as the statute previously was written in the version prior to 1994. Facts of this case really quickly, I think, are important. There's really no dispute as to the facts, but critically, the claimant did have a compensable accident. What we know from the adjuster's testimony and from the claimant's testimony is the carrier did not immediately authorize care. As a matter of fact, it was over 2 weeks before he was ever contacted and given any indication as to what he's supposed to do about getting care under the workers' comp system. He advises his employer immediately of the accident. He tells his employer, I'm going to the emergency room. He hears nothing from the employer after that, so he seeks out care with Dr. Bartoli on his own. Dr. Bartoli, who is clearly unauthorized according to the carrier's admission in the case and according to the judge of compensation claims findings, does a house call visit for the claimant, and subsequently the employer carrier pays for that visit some year and later, approximately May the 10th of 2023 is when the carrier pays for Dr. Bartoli's visit. Our contention is the statute of limitation was told 1 year from the date of that payment.
Let me ask you a foundational question about the statute of limitations. 440.19, subsection 1, talks in terms of, you just said he advised his employer maybe 10 days later or what have you. But then it says petition filed within 2 years after the date. A petition needs to be filed 2 years after the date. Am I reading that right, that a 2-year statute of limitations would have started right about that time in which he notified his, well, I guess from the date of injury, that a 2-year statute of limitations begins to run at that point?
Although that's not an issue that I think we addressed in our briefs, I would agree, yes.
Okay, and
but
then
I
in
think
subsection 2, I'm getting to a point here, subsection 2, then if any benefit or furnishing of treatment care attendance is provided, that 2-year statute of limitations gets tolled for a year each time the benefit gets provided.
Well, and I think more critically, and if I could put a finer point on your point, 1 year, it gets tolled 1 year from the date of payment. That is what the unambiguous language of this iteration of Section 440.19 states.
And in this case, there are at least a few payments. Well, they backdated some disability payments. I see there's an EMS payment, February 22, radiology payment of May 22, payment to Broward Health on November 22. So it seems to me that because the disputed PFB in this case was only 25 months out from the injury itself, that when you're talking 2 years, all we need is tolling for a month. In this case is free.
I suppose that would be an easier way to look at it than the way that we analyze it. You get to the same result.
Payments that in the very least told it for a year. It seems like a year and a half. So we would be looking at three and a half years post tolling under 440.19 in which to file a petition.
Yeah, I would agree with that interpretation as well. Again, I think we probably took a different path to get to the argument that the judge made a mistake and that the statute did not run in this case, but that is
So it seems to me like this isn't even close.
not even close. Not even close, not only by Your Honor's interpretation, but also not even close by virtue of the fact that the claimant filed his petition for benefits within 1 year of the date that the last benefits were paid in this case. And the last benefits paid in this case were obviously
Well, that's
May
more of the
10th.
dispute that you all have been having, but it seems to me like I just read 44019 and wait a second, why are we even talking about this? Because
Right,
this is,
why are we even here?
Okay.
Correct.
All right, go ahead, sorry.
All right. I guess I'll kind of get back to embracing the point that you made, but I think, what I would offer you is some secondary and tertiary reasons for reversing the judge of compensation claims. What I led with originally was that precedent does matter, right? And that this court in the Creed case and in the Arboleda case unambiguously held, now granted, this was a prior version of section 440.19, but in all other material respects, the tolling provision was the same. And what the court held in those cases is where there is not prior authorization that exists, or whether there's some question as to the EC's acceptance of responsibility, that the actual furnishing of medical care, right, does not occur until the carrier actually pays the bill. Now, what do we know in this case? It is a matter of undisputed fact. The carrier has conceded this, that the care with Dr. Bartoli was not authorized, right? So under Arboleda and under Creed, these cases tell us very clearly that the statute, the 1 year, previously it was 2 years, now it's 1 year, does not start ticking until the care is actually furnished. That care cannot be furnished until the carrier pays for it because it was not authorized, right? If we're dealing with authorized care, it's treated a little bit differently. In authorized care, there's a long lineage of cases that has discussed that.
Will you please help me understand sort of how your arguments fit together? Because it seems like in part of your brief is that the plain language of that last phrase, from the date of such payment, applies to both the payment of indemnity benefit or the furnishing of medical care. So does the tolling ever begin anymore from the date of actual care, or is it always based on such payment as you argue later?
Yeah,
in other words, are these precedents about the line between unauthorized and authorized even applicable now that we have the amendment?
Perhaps, well, if you were to accept my interpretation of how the statute is plainly written, then I would submit to you these other cases don't even really matter anymore, right? So I would suggest to you this is an issue of first impression. This court has never been called upon, at least that in cases that I've read, to actually look at the 1994 revisions to section 440.19 and decide whether the 1 year from the date of such payment applies to both the furnishing of medical care and the payment of indemnity. What do I mean by that is that it's not the furnishing of indemnity as it was under the prior version of the statute. Prior to 1993 and before, the statute very clearly, and you'll see this in page 29 of my brief, the chart that we laid out, the statute very clearly was written to state that a claim may be filed within 2 years after the date of the last payment of compensation or after the date of the last remedial treatment furnished by the employer, right? So there was a crystal clear legislative mandate that existed prior to 1994 that told you that the 2-year provision then, which is now 1 year, starts ticking either after you pay the medical or after the carrier furnishes the care, right? Now, if the legislature wanted that same interpretation to apply in these post-1994 changes, they just would have scratched out 2 and substituted 1, but that's not what they did, right? And this gets into, part of the arguments that we have as to how this court should interpret those changes. This is a substantial and material amendment in the way that section 440.19 has been written, right? And the only modifier now is 1 year from the date of such payment, right? And there's no rule of grammar, no rule of statutory construction that would allow you to take that modifying phrase that states 1 year from the date of such payment and have it only refer back to the initial, which is the provision of indemnity benefits, or payment of indemnity benefits. The rules of statutory construction, whether it's the last antecedent canon or even the series qualifier canon, tell you that this 1 year from the date of such payment either has to refer to both medical and the furnishing of indemnity, or it applies only to the latter, which is the furnishing of medical treatment.
Does the use of the phrase "such payment" indicate that, okay, we need to look for the same word above, and that's what that phrase applies to?
Such payment means either, right? I mean, such payment could refer to either. If the legislature wanted to, in a very clear, again, I'm going to go back to the point I just made, they know how to write the statute to clearly express their intent. This is what they did prior to 1994, but they didn't do it that way. They did it in a different way. And we would respectfully submit that this court is obligated to pay heed to that very substantial and material amendment and to interpret the statute as it is plainly written, right? This requires no mental gymnastics, what we're asking you to do here. This does not require any, anything other than construing the statute as it is plainly written. There is simply no way to take this phrase 1 year from the date of such payment and not have it apply to the furnishing of medical care. You would have to rewrite the statute to do that.
I mean, is there ever a scenario where medical care is furnished, but there's no payment involved?
Well, there could be. A carrier could conceivably, well, actually, I would say probably not, because the furnishing means the providing of care, right? So the claimant can receive the care, but unless that bill is paid, the carrier really hasn't furnished the care at all. I think that the furnishing of care goes hand in hand with the providing of the care, because if the claimant is somehow or another remains legally responsible for that care, right, say it's an unauthorized visit like it was in this case, then the carrier hasn't furnished him with anything. Right, he's received the carrier has furnished or provided precisely nothing. And this is, again, we get into this in our briefs about what is the plain language of the meaning of the word furnish, right? When we look at the supremacy of the text, which this court has followed in case again, it tells us, we look at these words in terms of their ordinary common sense meanings.
If the PFB here was filed a month earlier, it would have been within 2 years of the injury.
I believe it would have, yes, Your Honor.
Would this have been, would we be having this argument about subsection 2 of the statute? Or is sort of subsection 2 the whole playing field here, and it's...
Well, if the PFB was filed within the first 2 years of the statute, I don't think there'd be anything here to discuss. Right. In other words,
which was just a month, less than a month earlier.
Right. I think it was 2 or 3 months, maybe. I think, if I'm not mistaken, the petition may have been. No, that's right. It was 1 month. It was filed in March, and the 2 years would have run in February.
Is it your position that each payment of indemnity benefits by the importer carrier within the 2 year period extends or tolls the statute for an additional year?
Well, I think that's the fair reading that Chief Judge Osterhaus assigned to sub-provision 1. And I think that's the proper way when you read these two provisions of the statute, section 1, section 2, in pari materia. I think that's the only logical conclusion at which you could arrive.
Okay. In this case, is there any evidence in the record that the employer carrier knew of Mr. Bartelli's treatment or of the claimant's desire to seek treatment until the claimant sought reimbursement for the said treatment 15 months after the treatment was rendered?
No, Your Honor. To answer your question, no, the carrier wasn't aware of that, but I would submit to you that that was a consideration identified by the judge of compensation claims, but I would submit to you that it's pointless, right? It doesn't make a difference. It doesn't matter. The carrier had all, this is a carrier monitored system. The carrier had all the tools at its disposal if they wanted to find out what happened with the claimant and what medical treatment he would have received before he went to Concentra, that they finally authorized some 2.5 weeks later. They could have taken a recorded statement. They could have deposed him under section 440.30, either before or after a petition had been filed. They had all the resources available.
Claimant was represented by counsel, though, right?
Pardon me?
Claimant was represented by counsel.
He was represented by counsel.
His counsel made the claim for reimbursement.
His counsel claimed the reimbursement on his behalf, correct.
Under your reading of the statute, though, it seems as though the claimant has some control over when the statute is told by when the claimant submits the bill for reimbursement.
Well, yeah, I think that's the way the nuances of this case certainly play out. So I can't escape that fact. It's true. By the same token, the carrier had every resource to be able to investigate that, and they didn't. I just don't think it really is a relevant consideration under the plain text of the statute, right? The fact that the claimant had this information for whatever reason, I don't know why the record's silent as to it. Why did he wait as long as he waited? But the bottom line is, look, the carrier...
Was compensability of the claim an issue?
No.
In the proceedings below?
No, not, I mean, once the employer finally reported the claim to the carrier did accept the claim as compensable. So this was a compensable claim, just as the claims were in Arbidola, just as the claims were in Cree. I see I'm in my rebuttal time, so I'll save the rest for rebuttal. Thank you, Your Honors.
Ms. Fernandez.
May it please the court? My name is Kim Fernandez, and I have the privilege of representing Ascendant Claims Services in this appeal. We're here because the JCC used the date of treatment to start a tolling provision. We're not here because there's a question as to whether the countdown clocks were used correctly for counting down a statute of limitations. This is an important distinction, and there's one other important distinction that I need to make in my argument, and that is we're not here talking about the payment of a medical bill as the furnishing of medical care. As Judge Lewis pointed out, we're talking about a reimbursement of expenses to a claimant who has all the control of that information until he provides it to the employer carrier for handling, which happened 15 months later.
How late was he?
I'm sorry?
How late was this claimant's petition here?
The petition itself, it was 1 month beyond the 2-year statute on subsection 1. Another thing that was late, though, that I can't forget to mention is that he waited 15 months to submit any information about treatment that he sought on his own so that the carrier could deal with it. What the claimant's asking this court to do...
But you're saying it would be no problem if he would have waited 14 months. But because it kicked it over the 2 years, it was a problem.
Your Honor, it's always a problem when a claimant holds on to information that it wishes the employer carrier would act upon and then gives it at a later time. It's always going to be a problem when an argument is raised that the carrier didn't do what they were supposed to do if the claimant was the only person in possession of that information.
Well, it's not a problem if he waits from the 13th month to the 14th month, but you're saying it is a problem if he waits from the 14th to the 15th.
Well, it's not. You know why it's not a problem? He got paid his reimbursement. So it wasn't a problem. The problem the claimant has is that the judge didn't use that reimbursement date for statute of limitations. The judge used the date that he got that treatment with the unauthorized doctor that nobody ever knew about for 15
Counsel,
months.
is reimbursement to the claimant the same as a payment under the statute of medical benefits?
A reimbursement, obviously, is the payment of a check to a claimant. However, under 44019, the provision of benefits, the only benefits that a workers' comp claimant is entitled to is money for lost wages, just to put it simply instead of using the statutory terms, money for lost wages and medical care. So the payment of money for lost wages is a payment under the statute. The payment of medical bills for authorized treatment is the payment of, the benefit was the treatment to the claimant, not the payment to the third-party provider. Does that make sense? I hope I'm answering Your Honor's question. The payment of the reimbursement of expenses is categorized by carriers as a medical benefit because reimbursements only occur for medical aspects of their case. What the claimant's asking this court to do is actually reverse itself on a long line of cases going back 25 years, starting in 2005 with the Fontanills versus Hillsborough case, and as recently as 2024 with the Ortiz versus Winn-Dixie case. Two others to mention in there are the Gore versus Lee County case in 2010 and the Cheyenne versus City of Hollywood case in 2019. All of those cases contain this court's statement that the payment of compensation and the furnishing of medical treatment is what starts the tolling period for the statute of limitations. Your Honors, Judge Lewis and Judge Osterhaus, you were a part of a concurring opinion in Hospitals East versus Hampton in 2021, where in that case, on the 2011 version of the statute, which is the same version we're dealing with today, said the payment of an attorney fee is neither a payment for compensation nor the furnishing of a medical treatment. Those are the only two events that will extend the statute of limitations under 440.19.2. I point that out because over the past 30 years since this statute was amended, this court has weighed in on it. This court has interpreted it. And the claimant can't have it both ways, calling it a plain and simple, unambiguous language in the statute, and then also dig all the way down into the statutory history, the legislative history, the legislative intent. It's one or the other. And this court has weighed in on this time and time again, as cited in our brief.
Let's talk about the most recent one, right? The Winn-Dixie versus Ortiz case.
Yes,
that's
sir.
Pulling, first of all, it doesn't even cite 440.19. It doesn't discuss it at all. It just pulls language from cases dating from the mid-90s and earlier. So do those cases, with respect to this tolling provision, still control?
The cases that I cited deal with the new version. I'm not sure if Ortiz did or not. I understand what Your Honor is saying. It's going to depend on the date of accident as to which statute it's dealing with. Another word to throw in there, if we're defining words like furnish, the Ortiz case does use the word rendition. It says that the rendition of treatment, not the billing or the reporting of the treatment, is what tolls the statute. Billing is another important word because we're not dealing with billing. We are dealing with reimbursement to a claimant. That issue has never been addressed by this court, mainly because there's never been an issue with reimbursements to a claimant. You know why? They're paid. And in this case, that one was paid as well.
When was the last disability benefit paid?
I don't know the specific answer, Your Honor, but the evidence in the record will show that it was sometime in 2022. I want to say August, but I'm not 100% sure on
And
it.
that would have told the statute of limitations for a year, correct?
Yes. The
And
last,
then the statute of limitations would have started again, and that would have kicked it into 2025 or some such thing. It would have kicked it past the date of which this disputed PFB was filed.
I take issue with the counting down of the statute of limitations and whether it would have kicked it beyond today's date and where we stand with today's date, because the importance in this industry that's going to impact every single case in Florida is whether or not the furnishing of medical care versus the payment of a reimbursement to a claimant is what triggers whatever countdown a party wishes to argue about.
But you don't question that some payment was made in this case that required tolling.
I do not question that, Your Honor.
Okay.
As well, a lot of authorized medical care was provided, which also tolled
Sure.
every time those appointments were made.
But going back to my questions at the outset, we're only talking about a PFB being filed 25 months after the injury in this case.
Correct.
And so all we need to cover is 3 or 4 weeks. And if it was told just once for a year, then we are 11 months past what would have been needed, what would have made it timely.
I understand Your Honor's point. Unfortunately, it's not a part of this appeal. It wasn't raised by the JCC. It wasn't raised by the parties in the briefs. And so the countdown of when the statute...
But you're asking us to apply 440.19. I mean, we can read 440.19 and apply it here, and it seems like there's no real issue. There was tolling in this case, so the 2-year statute of limitations became at least 3 years, but probably something further because there were multiple payments. And so it just seems common. We're just applying the statute.
You're just applying the statute based upon case law that this court issued rather recently. I'm not sure of the status of the case law about the dual clocks running for tolling of the statute of limitations in the 2-year period. I don't know if that's done or if it went to the Supreme Court. I'm honestly not sure. Probably because I didn't prepare for it today because it wasn't a part of counting down for this case. To make
Counsel, taking that logic, though, would each payment within the 2-year statute of limitations period toll the time for filing the claim by 1 year?
Yes. Each payment made within the 2-year period of that statute of limitations in subsection 1 would toll the statute of limitations from running for 1 year. I agree with that statement.
And did the claimant ever request a payment of Dr. Bertoli's bill?
Yep. I'm sorry, what was the question about asking for the payment?
Did the claimant ever request Dr. Bertoli's bill be paid?
Correct. Never.
Did he?
No, I'm sorry, Your Honor. It was not requested until 15 months after the treatment was rendered, when his attorney submitted it to the employer carrier's attorney. There was never any indication that this treatment occurred, no medical records provided, anything. So the first time the carrier knew about it was 15 months after it happened, and the carrier took care of it the very next day. They paid it. How does this particular issue, how does it impact our entire industry in every case beyond this one? Because historically and statutorily, the employer carrier maintains control of medical benefits in order to expeditiously place needed benefits in the hands of the claimants. If they don't do that, there is a self-help provision in the statute, and that's what the claimant availed himself of in this case in seeking unauthorized treatment that he never advised the employer or the carrier about. 3 days after he went to the emergency room, 3 days after the date of accident, he questioned how he was going to receive ongoing care. The ER told him to follow up with his PCP, and so that's what he did. He followed up with a primary care physician 3 days later, being Dr. Bartoli. He did not tell anyone, he paid the bills, and that was the end of that, until 15 months later, when his attorney said, hey, you can get paid back for that, give it to me, and submitted it to the employer carrier. So, equating the furnishment of benefits with the payment of a reimbursement places control in the hands of claimants, because an employer carrier can't reimburse a claimant for something that they don't know about. You know, earlier this year, I litigated medical mileage because claimants under Section 440.13 are entitled to reimbursement for the mileage that they travel to doctor's appointments with authorized doctors and actually to pharmacists to pick up their prescriptions. But the claimants can't get that benefit until they tell the carriers where they traveled and how many miles they covered in that travel time. It's in the claimant's hands. And the reason I litigated this issue earlier this year was because a claimant submitted 10 years of mileage logs for payment. And the claimant was paid for that mileage based on all those logs. But it was a nightmare to verify all of the entries of logs for a 10-year period of time, but that is the benefit that the claimant is entitled to under the law, and that's what they got. But to now think back to that happening and to think about that submission, reviving a case close to 10 years after the statute of limitations possibly could have run if the claimant didn't seek treatment for long back when the date of injury, a date of accident happened, to be able to revive a case on their own years later by submitting such a log is a dangerous proposition for the entire industry.
How do you, how do you make sense of the new statutory language from the date of such payment as it relates or doesn't relate to the furnishing provision?
Payment appears twice in this subsection. It appears in conjunction with the payment of indemnity, and it appears again with a qualifier, such. Okay,
so your position is that there is no connection between the last phrase from the date of such payment and the furnishing remedial treatment, right?
That is my reading of the statute, but I do have one point to make on that, because there's lots of case law from this court that says if an employer carrier shuts you down and says, no, we're not going to authorize that doctor, we're not going to authorize this treatment, we don't think you got hurt at work, and the claimant has to go get their own treatment, And then the employer carrier changes their course later on in the case. Maybe discovery shows a video that indicates the accident truly did happen at work, and the employer carrier changes their course. If that happens, then there's no way to distinguish. The payment then of those medicals after the fact does equal the furnishment of the benefit, because until that day, nothing was furnished in the way of a benefit, if that
And
makes
I
sense.
think I understand how you get to that sort of qualifier through the case law.
Yeah.
Do you have a basis in today's statute for that scenario?
A basis in today's statute for the scenario of furnishing.
So that's how you're interpreting the phrase furnishing the same way that the 90s and 80s court did as well. Is that correct?
Well, I would say I'm interpreting it the way this court has, because this court has said it several times in the cases that are cited in my brief. They've said it: the provision of medical treatment, the rendition of medical treatment, the furnishing of medical treatment. Those are the terms that this court has used time and again as the start of a tolling period.
Well, Counsel, you do agree that 448.19.2 is clear and unambiguous?
I agree. This court has said it time and again. They've interpreted the plain meaning of the statute time and again, and they've always used the furnishment date of the treatment as the starting of the tolling period. Equating the furnishment of benefits with the payment of a reimbursement puts control back in the claimant's hands and more importantly, makes the employer carrier lose control of benefits that they should be providing to a claimant under 440, but they don't know about it. I don't know if there's any other families like mine that operate like this, but when my family does a puzzle at home, some of us hold a piece. We steal it, and we keep it until the end, because then we get to put that piece in and say that we finished the puzzle. That's the kind of gamesmanship that goes on in my house, but that kind of gamesmanship has no place in the workers' comp field. Holding on to something in order to save yourself from a statute of limitations later has no place, and that is certainly not what the legislature contemplated when they wrote this statute. They wrote the statute to allow a claim to die a natural death based upon the provisions in 440.19, and they did not intend to provide a gotcha provision to hide a benefit from an employer carrier so that it could later revive the entire case for the reimbursement of an expense. If your honors have no more questions for me, I would just ask that the JCC be affirmed in this case.
Thank you, Ms. Fernandez.
Thank you, Your Honors. Let me, I guess, begin with the last sort of, allegation of gamesmanship. I would think that's really quite absurd in this case. Look, the carrier was well within their rights to have taken that bill that it received from Dr. Bartoli and denied it. They didn't do that. They paid it. Why? The ostensible reason why they paid it is because they knew they didn't authorize care timely. They put the claimant in a self-help situation. He had to get the care on his own. None of that really matters, though. None of it really matters. This is not a situation where this payment to Dr. Bartoli revived a case that had been otherwise dead by the statute of limitations. At the time, the claimant submitted his request for reimbursement. By even the carrier's iteration, the claim was still open, alive, and kicking. All that payment did was exactly what the statute tells you that it did. It told the statute of limitations from 1 year. 1 year from what? The date of such payment. Critical language. Judge Treadwell, I want to pick up with one of your questions because you referenced Ortiz, and I found it to be relevant when I went back and I looked at Ortiz about all of the cases that were cited within the body of Ortiz that talk about the furnishing of medical care being the operative date. Every single one of those is a case that interpreted the pre-1994 version of the law. That's important, right? Because whether it was, I don't think this was the central issue in Ortiz as well, which is why I would submit to you that what the carrier has told you about how this court has decided this issue over and over again, it is not. This is an issue of first impression. Any other statements, including the statements that I make in reliance on the McBride case. McBride is the case where this court in 2005 talked about how the statute of limitation works and how it would operate to toll the statute 1 year from the date of payment of the bill, is the unambiguous language this court used in McBride. But McBride was decided on other grounds, just like all the cases that the carrier has referenced to you were cited on other grounds. The issue of first impression here is, what does 1 year from the date of such payment modify? The carrier would have you believe that it jumps the nearest antecedent, which is the furnishing of medical care, and applies only to the payment of medical. That makes no sense. That interpretation, quite simply, is not congruent with either the plain language of the statute. It is not congruent with any of the typical rules of statutory construction that we would apply, the canons of construction. You simply cannot, in good faith, get to the position that the carrier is asking you to get to based on the plain language of the way the statute is written. The phrase 1 year from the date of such payment clearly refers to both things. It refers to the payment of indemnity, and it also refers to the furnishing of medical care. If the legislature, again, had intended that they wanted it to be the way that it was before, and they didn't want to make a substantial and material change, the easiest way to do that would have been when they changed the statute in 1994. You scratch out the word 2, you put in the word 1, easy peasy, right? That's not what it did.
Was Dr. Bartoli an unauthorized physician at the time of the service?
Yes, sir. There's no question the adjuster admitted as much, that Dr. Bartoli was unauthorized. And I think that...
Does that create a question as to the carrier's acknowledgement of responsibility?
Well, this is I'm glad you brought this up, because this is the point that they never answered really in their briefs, and I didn't hear them answer today, right? And that is, how could the carrier be deemed to have furnished the care with Dr. Bartoli, who was unauthorized, who the carrier never said you can go see her, until they paid it? This is the folly, I would submit to you, of the appellee's position, that they are asking you to basically agree with the judge of compensation claims that care that they never knew about, that they never authorized in advance, was somehow furnished by them. You can't do that. The only way that this care could reasonably have deemed to have been furnished by the carrier was when the carrier paid for it. And the reason for that is, as you alluded to, Your Honor, because the carrier had not authorized it in advance. So, Your Honors, we are asking that you reverse the judge of compensation claims and award compensability of this case on the grounds that the statute of limitations was improperly applied by the judge. Thank you for your time.
Thank you, Mr. Weiner. Ms. Fernandez, thank you. That concludes our oral argument.